All rise. Court of Appeals Division 1 is now in session.
Morning. You may be seated. We are here today on our case number 1CACV160141, Gonzalez versus Nguyen. Counsel, as you know, each side's allowed 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve time, you're in charge of keeping track of it for yourself, because the clock on the podium will reflect the total amount you have remaining, including what you may have decided to reserve. We record these proceedings, so when you approach the podium, we'd be grateful to you if you would give us your name and the name of your client for the recording. We have read the briefs, and we've studied the record, and we've also discussed the case in our conference. So, with that, Ms. Freeman, you may begin.
May it please the Court, Susan Freeman on behalf of Plaintiff Appellant Gonzalez's. Your Honors, the Riches, Penzino, and Hawk cases govern this particular case. In Riches, our Supreme Court said that there has to be an affidavit upon personal knowledge that the insurer had excusable neglect, which includes knowledge of specific facts as to what occurred and why it was excusable, plus affidavit evidence of a meritorious defense, which must be more than this is a trip and fall, and assumptions arising from that. And if you don't have that, the court said that it is error to vacate a default judgment. It was a 60C1 case, but the court expressly said that 60C6, an insurer must be blameless, and the insurer is not in this case. The Supreme Court went further in the Penzino case, saying that there is no entitlement to 60C6 relief when there is no excusable neglect. Justice McGregor said for the majority, we cannot consistently hold that Rule 60C1 allows relief from a judgment only for excusable neglect, but 60C6 allows relief from inexcusable neglect. And likewise, even Justice Feldman in the dissent recognized that inexcusable neglect does not entitle one to 60C6 relief. There were earlier cases back in the 70s and early 80s, the Camacho, Dungan, Mayhew, Rhodes, ultimately the Hawk cases, that had said that if there is such little evidence of damages as to shock the conscience of the court, that the liability case could remain, judgment could remain, but the damages could be examined by the court. And it could be vacated to that extent. Now, those were cases that were before Penzino. I certainly question whether they are still good law. But even if they were, the court in Hawk was very clear that these cases are you're looking at a shock the conscience standard, no evidence or so little evidence that it would not, it is shocking. And there is new evidence. There has to be new evidence that's presented at the motion to vacate a default standard.
Ms. Freeman, I understand your argument to be broader, that even if C6 permitted an inquiry into excusable neglect, you believe the other elements required under C6 are lacking here, correct?
That's correct. There is no inexcusable neglect. There must be excusable neglect, and that there must be evidence of a meritorious defense. And just the fact that this is a low-impact case, that it's like in Riches, it was just a trip and fall case, that is not enough. That is not new evidence that must be brought forward. Now, in some of the cases, like Dungan, the court said, let the defendant come in and ask for an extension of time to take discovery before the default judgment hearing, and then we can consider the additional evidence. That was not requested here. They did nothing. They received certainly sufficient notice, more than adequate, more than the required notice, and they did nothing until 26 days after the default judgment was entered.
What, in a case like this, where we're not talking about liability, we're talking about damages, what would a defendant need to show, dispose to demonstrate a meritorious defense?
First, there would need to be so little evidence of damages in the first place as to shock the conscience. And here, there was extensive examination on the record of Mr. Gonzalez as to his injuries, and the liability, of course, was already admitted, so you didn't need to get to causation or the fact of the accident. But he did have extensive testimony, and then there was a presentation of medical evidence that the court reviewed at length before entering the default judgment. So you had that in the first place. Then they did not come in with any evidence of anything that was wrong with that. They did not take discovery in advance. They did not come in and say this was that there was in fact no injury to the neck. There was only injury to the shoulder. The complaint alleged there was injury to the neck and shoulder and back that was caused by this accident, and that liability and causation was admitted by virtue of the judgment.
There are
Yes.
a couple of factual matters I'd like to just clarify in my own thinking, and you know the record better than I, but at that point, as I recall, there was a detailed demand letter sent in around August, about 6 months before the default proceedings began, that booked damages of over $700,000 and demanded $690 roughly to settle. Is that
That's correct. It was actually almost a year before the default judgment hearing.
All right. And then prior to the motion to vacate, the defendant's agents also had the packet of information that plaintiff's counsel submitted after the default judgment hearing documenting different kinds of damages, correct?
That was all served on them. It was served on both of the agents for the insurance company, and there was express telephonic and email notice. We're going to have the hearing in 10 days. You know, the notice is 10 days. Come if you want to come. They knew they had an opportunity to review that, and they could have come in, and they did not. And what's important here is that the trial court expressly found that there was inexcusable neglect, and there is, and it expressly found too that this was not shocking the conscience of the court. In that, if the court looks at transcript page 30, the court said it was expressly not making a determination that the judgment itself is grossly unfair or unjust. It expressly said that this is at page 6, the number is as good as any. It's a possible number because of ongoing pain and suffering and medical evidence and evidence of permanent injury. In the minute entry, it said this seemed fair. It's a tie between that and the grossly inadequate response of the insurance company, the casual claims handling. That is not a shock the conscience standard. There is evidence, and the court was recognizing that evidence, and there was no new evidence, as Hawk requires, even if Hawk is still good law and Panzino has not overcome that.
What do we make of the fact that the court, though, went on to say, I'm not so sure about what I did before. I'm not so sure about the finding that I made before.
And that's precisely the point, that it needed to have more than that. That was error as a matter of law. The standard is not justice, simple justice, tie goes to the runner. The standard is that it has to be so deficient as to shock the conscience of the court. There has to be new evidence, actual new evidence, not just it was a low impact case, and there must be inexcusable neglect. And we have none of that. And so as a matter of law, this judgment, this vacating of the default judgment was erroneous. This is, if this kind of a default judgment can be set aside, then we might as well wipe off the whole rule on default judgments, let alone riches, because if it's enough just to say, there was an administrative error and it was a low impact case, then you have nothing. That there's any default judgment can be set aside. If the court has no further questions, let me reserve my remaining time for rebuttal. Thank you.
Thank you. Mr. Ackerman.
May it please the court, my name is Justin Ackerman on behalf of defendant at police Kwok Nugent and Dysart Hotel. With me at council table is Bill Caravetta, who's also a partner on this case. Let me start with Panzino, and I can obviously defer to the court's questions from there. Panzino was a case of positive misconduct, and whether that would be applicable in the attorney-client setting. I think for several reasons it's not applicable in this case. The first of which is that we did not request relief for excusable neglect, and that was what was at issue in Panzino. The court was being asked in Panzino to adopt, essentially, excusable neglect under Rule 60C6.
Well, let me backtrack, because I think it was pretty unclear exactly what you were requesting in the trial court. The motion to vacate did not cite anything except Rule 60C. When the response came back and focused on C1, the reply said nothing about Rule 60 at all. Then an oral argument on the motion to vacate, both 60C1 and 60C6 were cited. So I took a little bit of umbrage at the indignation I sensed in saying it's always been a Rule 60C6 case. I don't think that's accurate.
We did cite 60C6 at oral argument, and I think that's the clearest.
And C1, though.
I agree, but
You just cited the rule 60C with all its subparts, and there was no specific mention of 60C6. There was actually no mention of any other subsection of 60C in your motion or your reply. Is that correct, counsel?
that is correct. At oral argument, it was explicitly stated that C6 was one of the bases we were moving on, and the court had requested prior to oral argument that we specify which provision we were talking about for oral argument, and that's what we did. And when the court ruled, it did rule under justice considerations, which is a component of Rule 60C6.
It is, but it completely failed to mention the meritorious defense requirement. And if you didn't establish a meritorious defense, you weren't entitled to set aside the judgment. So what in this record established a non-speculative meritorious defense to the damage award?
I think you're entitled to look at the evidence that has been submitted. I disagree that you have to submit new facts. I think you can look at the record that's been submitted and question whether or not adequate evidence has been presented in support of the default that's been entered.
But that would be true, as Ms. Freeman says, in every default case, because the nature of a default is it's one-sided. The plaintiff puts on evidence, the defendant doesn't show up. A defendant can almost always, except in a liquidated damage setting, come in and say, hey, that award is too high. Let's parse it. Let's look at this. And at oral argument on the motion to vacate, it seemed the speculative nature of the defense was pretty clear because counsel conceded this may be a valid figure after we do discovery. There was nothing shown to the court that could say, and that's why I asked Ms. Freeman, your client's agents had all of the documentation for a long period of time and presumably could have come up with something. And so I'm just not seeing anything in the record supporting a meritorious defense.
Well, again, I think you're entitled to point to the record and question whether it exists. The Hawk case, as they cite, does say that you can look and see if there is scant evidence presented to the court. And I understand that there was a lot of evidence documentation-wise that was given to the court on their injuries. But in terms of documentation on causation for the evidence, there was only one letter that was submitted in the record that I'm aware of where the treating physician simply just concluded that the damages are related to the injuries that were sustained. And it wasn't a sworn letter either.
No, but we had all of his medical records. He was the surgeon. I mean, I understand that you can poke holes in it, but I don't think that's enough to just say, well, if we're allowed to do discovery, we may find that this number's wrong. That, again, that would upend every default judgment when a defendant could challenge the number. And it seems to give short shrift or no recognition at all to the notion of finality of judgments. I
understand that, but on the same vein, Rule 60C6 is the broad reservoir to do justice in a given case. The trial court sat through that default hearing. He heard all of the evidence and testimony. He reviewed those records. He observed the arguments in support of and against the motion to vacate, and still at the end of the day made a decision to decide that the evidence that he reviewed wasn't supported by the record. And to your point, he admitted on the record he did not conduct an adequate review of the things that were submitted. I think that in and of itself is an extraordinary circumstance under Rule 60C6 to vacate the default judgment. when the trial court
he
admits
said
a
that he
committed
didn't
error.
review it as careful as he might have, and that now you are raising these issues. It seemed a little high, but let's follow up on something you just said, because
Sure.
I think it's important. The Webb case, the Arizona Supreme Court does say that under 60C6 you have to find extraordinary circumstances,
Mm-hmm.
and I'm having difficulty with that here. We have inexcusable neglect. We have arguably an overly generous award as it relates to pain and suffering, but we also know that your client's agents had all of this information and knew that the plaintiffs were claiming over $700,000 in damages well before the default proceedings were going. So I'm just having difficult understanding what's extraordinary here.
Sure. Let me talk about Mayhew and Union Oil in response to that. Mayhew, it's dated, I get that, but it's still good law. Mayhew held that under excusable neglect, Rule 60C1, notice to an agent is notice to an insurer, but then turned around and granted relief under 60C6.
Under on abuse of discretion, that was affirmed. I get that.
Yes.
Yeah.
Now, Union Oil, the case that came much later, in, I believe 1982, in that case, notice and the complaint were provided to the insured. Then that was provided to the insurer's agent. And then that was provided to, or sent to, I should say, the insurer. The insurer in that case claimed that they never received that notice, and the court did not impute any sort of knowledge between the insured and their agent and the insurer. We argued under Union Oil that there is a lack of knowledge here. And I think the evidence is there in the record. There was all the correspondence that was sent was between the insurance administrator, Precision, and plaintiff, and Carl Warren, their agent, and none of it was CC'd or attached to Companion. And I think that the Mayhew case and the Union Oil case are really focused, because of the justice considerations under Rule 60C6, on what the insurer actually knew.
Well, I don't think there's any way that Companion can claim, because I hired these people to administer the claim, they told Mr. Gonzalez's counsel to communicate only with me, that then Companion can just remain ignorant and come in years later and say, I never knew this.
For purposes of Rule 60C6, I would argue that they can, because it's focused on what they actually knew.
But Companion was not allowed to intervene. In fact, you all kind of agreed that its interests were represented otherwise. I'm not sure that's an argument that anybody either had standing to make, or it's certainly not something that the trial court focused on.
Well, the court acknowledged in its index of record 55 before the proceeding, before the oral argument on the proceeding, he acknowledged that Companion did not get direct notice of the complaint or the default. It had recognized that in the record. It acknowledged that Precision and Carl Warren got notice, but it acknowledged that Companion did not. So that was something at least that the trial court considered prior to oral argument.
That just can't be excusable neglect.
I'm not arguing it is.
That an insurance company hires its own adjusters and then says, I can remain ignorant, and then claim I knew nothing if they screw it up.
I'm not arguing it is, and I don't think I have to show that it is excusable neglect whatsoever. I'm sorry. I'm interrupting.
No. I'm interrupting you, so I'm not sure why we went there then. Do you know?
I'm trying to show that there's extraordinary circumstances, not excusable neglect. Excusable neglect is only required under 60C1. We cited cases that show Amonte, Mayhew, not Union Oil, Higgleman, and M&M Auto Group. All of those cases found inexcusable neglect, but still granted Rule 60C6 relief.
What's the implication, if any, or the significance, if any, to the fact that the bulk of the damages here were apparently awarded for pain and suffering, as to which, I mean, absent surveillance video, which I know defendants sometimes gather to impeach a plaintiff who asserts as the result of the injury, I'm not able to do X, Y, and Z. Absent that, the counsel for the carrier could do little more than just cross-examine the plaintiff.
Mm-hmm.
What's the significance of that to the meritorious defense issue?
If you're asking me what more you could have shown, my answer would be you could have provided an IME on the plaintiff an independent medical examination where another doctor could have come in and said, what are your actual injuries? You could have obviously cross-examined the plaintiff. You could have had an expert look at his records and say, were these truly necessary? These are all the things that we would like to have discovery on, and that is currently stayed because of this appeal.
But even at the end of the discovery, your counsel at the oral argument said they could be dead wrong, and the $660,000 may be reasonable. So doesn't that cut against your meritorious defense by that concession at oral argument?
I think that was a off the cuff remark. I don't think that was meant to be a binding legal statement. But to the extent that you find that it is, I still think that his arguments at oral argument that these damages weren't justified by the evidence that they submitted on the record can demonstrate that there is a meritorious defense. And the meritorious defense only needs to establish that the facts that you assert, if proven at trial, would constitute a defense.
But again, those assertions have to be more the conclusions or assumptions. There should
Right.
be
Well,
some, and there
sorry.
wasn't presented before the trial court. Isn't that correct? It was just mainly conclusions and assumptions at that point.
I don't agree that they were conclusions and assumptions. I believe that they were looking at the evidence and saying we're missing something here to generate the causal link between all of the damages they submitted and all the evidence that
How
they
is that
submitted.
not an assumption?
Because you have to show that there's causation. For example, they submitted evidence that there was lower back injuries. There's no evidence in the record that demonstrates that the lower back injuries are directly related or caused by the accident. And to the extent that they're arguing because of the default that's admitted that we've admitted causation, that's not true. You only admit what was asserted in the complaint. And the complaint just simply asserts damages to be proven at trial.
So, Ms. Freeman talked about the burden of a defendant seeking to set aside under 60C to come forth with new evidence to show a meritorious defense. You're contending that that's not necessary, that a defendant may simply argue that the trial court got the evidence before it wrong.
I'm arguing that when the trial court is presented with evidence to support the default, and that evidence is inherently and fundamentally flawed, and that circumstance, that narrow circumstance, you do not need to submit new evidence to support a meritorious defense.
So fundamentally flawed, is that your test, or is that a?
Well, is that the test? Because I'm reading from the United Imports case, and this is a quote. A showing of a meritorious defense requires a showing by affidavit, deposition, or testimony of some facts which, if proven at trial, would constitute a defense.
I understand that the courts have used phrases like affidavits or testimony, but I don't believe that is an absolute and hard and fast requirement under 60C6. Again,
What's your best authority for it being something less than what I just read from the United Imports case?
I would cite to the Roll case. The Roll case explicitly.
Which one?
Roll v. Janaka.
Is that, because United Imports is a Supreme Court case.
That is a
Roll?
Court of Appeals case.
Okay. I'm going to have a hard time with that, then,
I understand, but the Roll case does say that plaintiffs aren't entitled to a windfall in asserting their damages. And I believe that would be what would be established by this case, and that is essentially what the court found when it ruled that they should vacate the default judgment. It said, I'm balancing here. On the one hand, I felt before I reviewed the evidence in light of the motion to vacate default judgment arguments, I was on the fence, but because there was nothing to contradict it, I granted it. Now that I've been given evidence and I have questions that have been re-raised, it's not just. I recognize on the one hand that they provided evidence to support it, yet it is still unjust. And that is what he said. He followed up with, after he recognized that there is evidence to support it, he said it still is not supported by the record. So in essence, he would be saying, if I had to affirm this and not vacate the default judgment, I would be granting them a windfall. Just one more point on Panzino. Let me return to that very quickly. Panzino was based on agency relationship, and we've been talking kind of tangentially about agency here. I think an important consideration that you should have in front of you as you're deciding this case is that Panzino is an attorney-client relationship. It is direct. It's clear. Here you have an insured, insurer, third-party administrator, and their agent. It's a four-part relationship, and case law in Arizona has explicitly held that a third-party administrator owes absolutely no duty to an insured. So I question how much you want to draw a line, how analogous, the relationships are between Panzino and this case.
But it does owe a duty to the insurer as the party with which it has contracted. The administrator.
No, it does not. That's the.
Doesn't owe a duty to the insurer?
Oh, I'm sorry, the insurer, yes.
Yeah.
Yes, it does.
Why don't you just go after them? Then you don't have, you're not on, I mean, really, their mishandling is shocking of the matter, setting aside companion, but they're the wrongdoer here.
Precision is, and I'm not saying that Precision's affidavit establishes excusable neglect, but I am saying that it doesn't establish that Companion has any neglect or fault in the entry of the default. Precision came forward in their affidavit and said, for lack of a better word, we screwed up in the management of this case.
So Companion's beef should be with Precision.
Correct, but to the extent you're going to hold the insurer liable for the default, which was entered because of negligence of a third-party administrator, again, we're looking at what the insurer did and what the insurer noted. Even Righteous, which isn't a 60C6 case, it's a 60C1 case. But even Righteous recognized when analyzing Union Oil, you look at the fault of the insurer, and the insurer here has no fault. According to the record that's before this court, the only thing that is, it's uncontested that Precision is the one who screwed up, and that's it.
Yeah, that's kind of their agent, though. That's where I'm having a hard time with viewing Companion as anything but in the same shoes as Precision. They hired Precision. They delegated to Precision. I don't think they can then just stay.
I understand that. I take your point. But, again, the default is entered against the insured. It's their names on the default judgment. And although Companion may be on the hook for it, to pay for it, it still affects their credit. It still affects them in other ways. The default is entered against them, and the third-party administrator owes no duty to them. So I understand your point, but I take issue with directly applying what Precision may have done onto the insured. If the court has no further questions.
Thanks. Thanks, Tom.
Susan Freeman on behalf of the Gonzalez's again. First, the Hawk case said at the very beginning, can the trial court set aside a default judgment because of the amount of damages awarded absent new evidence of that the amount of the award was not justified? We hold that it cannot. It needs new evidence. Number two, there was no need for evidence of causation because this court ruled in the Cherry case, along with the Dungan case, that the default is a judicial admission of liability for the alleged injury and causation, and that only the amount of damages is left open. There was no need for evidence of causation. With respect to the record being inadequate for review, or the court saying that it would be granted a windfall if in fact this prevailed. No, the court did not say that. It said it may. It said it may be reasonable. It's not making a determination of grossly impaired. Seems unjustly large. Seems, in retrospect, but unsupported because it did not have the cross-examination. And if there had been cross-examination and additional evidence, then the court would have reviewed it more carefully. But it reviewed it enough for this purpose. There is no evidence that the insurer did not know. The first notice was actually mailed to the insurance company, and then there was a response from the claims agent, and that's in this record, the exhibit to our response to the motion to set aside a default, mailed to the insurance company whose name was on the little insurance card that the defendant gave at the hearing. So it was mailed, and the agent came back and said, I'm the one representing, respond through me. The motion to vacate the default says, Defendant Dysart placed its insurance carrier, Companion Commercial Insurance Company, on notice of the claim through its claims administrator. It's acknowledging notice that went to the insurance company. There is absolutely no evidence in this record that the insurance company did not know. There's only arguments of counsel. The affidavit says nothing about the insurance company not knowing. The affidavit is just from from Precision, from a Precision representative. There is, in fact, prejudice if, in fact, this gets set aside. There's significant prejudice to my client as a result of that. He not only has to pay the attorney's fees for me to go forward and handle this. There's a delay in recovery, certainly discovery settlement leverage, and expense and risk of trial. If this judgment is set aside, then there is no interest from the date of the default judgment, so we have a significant loss in interest. There is damage that is resulting to my client if, in fact, this is set aside, and there's no basis under the law to do so because you have inexcusable neglect. And so even if the Hawk line of cases governs, then because of Panzino saying that inexcusable neglect is not enough to get even 60C6 relief, but even if the Hawk line of cases governs, you don't have the evidence, actual evidence of a meritorious defense here. All you have is, this is a minor, low-impact case, and therefore the evidence must be wrong. Could be right after we take discovery. Could be that pain and suffering is there, but not enough.
It's interesting. Mr. Ackerman urges that we kind of use the trial court's conclusion that it might have weighed the evidence incorrectly as a proxy for an adequate showing of a meritorious defense. Kind of the way that I understand what he's saying is that we know the carrier offered a meritorious defense because the trial court said it was meritorious. But what post hoc do we have that supports the proposition that, no, asking the judge to reweigh what he did before, he or she did before, is insufficient? You need to have evidence. What post hoc do we have?
We have the whole Hawk line of cases, and we certainly have the Panzino case and the Riches case. Riches is directly on point in saying you need more. You need an affidavit that includes more than just this was a slip and fall case. You need to have actual evidence that comes in order to proceed on this basis. Number one, I don't think the court said ever that it would be a windfall. It said that it might be if I had had more evidence to look at, then I would have looked at it more carefully. But that's the point of trial judges don't have to look at it all carefully. They need to have enough in the record. They need to be able to review it. He did. If the court looks at the transcript of the default hearing, then you'll see that the judge questioned the witness at length. Well, what about this? What about this? What's your evidence on this? Requested the additional medical evidence and reviewed it before entering the default in the first place.
Is that quite substantial in terms of what, after the default hearing, wasn't the turning over of the medical records, wasn't that a substantial
I believe it was 5 volumes of documents. It had to be broken up into 5 volumes in order to manage the electronic filing. Yes, there was a substantial amount of evidence.
I think you said in your earlier comments that was all copied to all the entities on the other side of
it was. The response to the motion to vacate the default includes an affidavit of counsel for the plaintiff that he had mailed copies of all of this. And in fact, most of the evidence was submitted even earlier, along with, and in fact, it may have been all of the evidence that was submitted earlier to the insurance company, along with the demand for $700,000, or saying we have $716,000 of damages, which includes $600,000 of pain and suffering. They knew that for nearly a year, and they still did nothing. They still did not come in. And again, I would note that Cherry says you don't have to have any evidence as to causation because that's part of the default on liability. Only the amount of damages remains at issue, not the underlying liability, and liability includes causation as well as the fact of the injury. Let me just note quickly with respect to the motion to strike that, of course, we can respond to issues and arguments that are raised in a in a motion or raised in an answering brief.
Can I direct you on that one? The only part of the motion that gave me pause was the Unfair Claims Settlement Practices Act discussion. I don't think that was preserved in the trial court. Would you agree with that?
It was not raised in the trial court, but it's not being raised here for purposes of liability.
But why do you
Liability
need
is already determined. The point is that this is like the guy who murders his parents and mercy, mercy, I'm an orphan. I mean, they're the ones who were at fault. They did not undertake the investigation that the law requires them to undertake, even in a low-impact case. And then they come in and say, oh, we didn't have discovery. We need discovery. You were supposed to have gotten discovery. You were supposed to have investigated it carefully, even in a low-impact case. And you didn't. So to now come in and say, I need relief, it's unjust because I didn't have that. Again, we're not saying this is something to prove liability. It is an additional argument, additional authority for why their argument of a meritorious defense just does not fly. And I think that's what we are entitled to do in a reply brief. We noted it earlier. We could have put it in the opening brief, but as we were doing additional research in preparing for the reply, that was the point that we found, and so we brought it to the court's attention and believe that it is relevant only for that purpose. So I guess I come back to the point that even if this was a situation of damages that are on the high end, as the court recognized, that's what happens when you have a default context and the insurance company does not come in. The insurance company could have come in. They certainly had a ton of notice, much more than was required. You had the initial notice of the claim that goes to the insurance agent, to the insurance company. You have repeated notice to the insurance agent. You have emails, you have calls, you have saying, you've got 10 days, and they still did nothing. Panzino says when you have inexcusable neglect, you're not entitled to 60C6 relief. You're not entitled to 60C relief. I think Riches says the same thing, and they did not have any actual evidence of any meritorious defense. The trial court didn't give them one, and on this record, it would be, it's an error as a matter of law to have set aside that default. Court, have any questions?
Thanks. Thank you very much. Thank you to all the lawyers for your briefing and your argument. We'll take the matter under advisement and issue a decision in due course. Now we stand adjourned.